Hello everyone, this is Albert Espinoza and this is week 6 of our MPA 545 course with Professor Curtis at CBU. And in this week's presentation, I'll be giving you a summary of the 4 new ADRs that we learned from our textbook, as well as from 4 scholarly articles I was able to find on each one. I'll give you the similarities between the article and the textbook, as well as provide you with a summary of the thesis from the journal as it relates to that specific ADR. So with that, let's get started. The first ADR I will touch on is early neutral evaluation, also known as E&E. Both the course book and the article I researched stated the courts typically appoint a neutral, who is usually an attorney, to assist in the case. The textbook mentioned typical cases include employment discrimination, personal injury, and the article I researched touched on family law cases such as divorces and any sort of disputes with wills. Both the course book and the article did state the choice of the neutral is crucial to the case because you want that expert in the subject to provide a level of reliability when it comes to their thoughts and opinions regarding the potential outcome if the case were to go to litigation. The thesis topic of the article was that E&E is a better form of ADR over mediation because a mediator is not allowed to provide an assessment of the parties' positions. Where in the E&E process, the independent expert will provide a direct assessment of the case, and the two sides receive almost a reality check if the case were to go to court. And this approach serves as an effective settlement tool for the case to reach a resolution without having to go through a lawsuit case. The next ADR is the mini trial, and both the course book and the article I researched stated that the mini trial concentrates on the critical issues and relevant facts of both sides while creating a focus solely on the legal merits of the case. Some of the cases include contract disputes, patent infringements, employee grievances, and other forms of litigation. The cost for a mini trial is more expensive than mediation or arbitration, but less than if the case actually went to court. Typically, a well-respected attorney or retired judge is chosen to hear the case in an informal setting, which is not controlled by lawyers. And both the course book and the article did state this is a voluntary process, which is non-binding and normally will last 2 to 3 days. The thesis of the article looked at mini trials as effective judicial actions and techniques in promoting effective settlements in the state of New Jersey. And it went into details of the values of mini trials and something else called matchmakers, which I will not go into much details of. The next form of ADR is a summary jury trial. And both the course book and the article stated a summary jury is a trial that is non-binding, and it's typically done in one day with a jury selected to hear the summary of the case. After the verdict by the jury, the two sides are instructed to meet once again and attempt to settle their dispute before it goes to litigation. The article mentioned no witnesses are present. Instead, the jury receives a summary of what the witness's testimony was from the two sides' attorney. The process is shorter, and it produces the same tensions that are found in a traditional jury trial. And if anything, the parties get a glimpse on how a jury might view the facts of the case in order to facilitate and entice settlement discussions. The article's main point was that litigation should be left for more controversial cases, and that a summary jury is a great form of ADR to focus on settlement skills while saving both sides time and money. The final ADR from our readings this week is the Dispute Resolution Board, also known as DRB. And both the course book and article mentioned that DRB is predominantly used for civil infrastructure projects. The board is typically made up of 3 panel experts who are independent and experienced individuals who are respected by both parties. Typically, the owner of the project selects one individual, the contractor another, and the 2 groups select a 3rd member to be the chair of the DRB. Both parties have the ability to choose the board, which creates a sense of fairness for both sides when disagreements do occur. The article mentioned the board members participate in meetings, have the plans and specifications, and are kept up to speed on the progress of the construction. When disputes do arise, the board can act quickly and prevent delays to the construction schedule, which saves time and money for all involved while keeping the disputes confidential as well. The article's main point stressed that DRB is the best form of ADR for construction projects because it promotes good relationships between both the owners and the contractors to prevent delays and disputes as the project progresses. And a news article I found was from the Sacramento Bee, and it talked about how Caltrans is using DRBs for their maintenance projects to help resolve disputes between Caltrans' organization and their contractors. And this is good to hear because it can save taxpayer dollars. Instead of going to litigation, they can handle some of these disputes during the construction and maintenance side of things and reach better settlements. Here are all my references for this week's multimedia presentation. I hope you enjoyed this. I can't wait to see your comments and see your videos. Have a great one and God bless. Bye.